Good afternoon. My name is Paul Locke, and I'm going to moderate this panel today. This panel is going to discuss some of the very important developments in the field of laboratory animal law. And laboratory animal law really involves a relationship between non-human animals used in research, testing, and education, the institutions in that field, as well as the individual researchers or educators that carry out research or look to animals for education and testing. Now, one of the major goals of this panel is to give you some insight into this exciting field of animal law. I want to note that the topic was first presented at the Animal Law Conference in 2007. Though for those of you that are good at arithmetic, you'll know immediately that was about 17 years ago. And since that time, there has been significant progress in this field, especially in the development of non-animal models to replace animal models. And there's been some legislative developments too, but like most fields in animal law, we have a lot of work to do. So you're going to hear a lot about what needs to be done as we delve into these topics. So what am I going to do today? I'm going to introduce the panelists, and then I'm going to take a few minutes to kind of give you a windshield tour of the ABCs of laboratory animal law. After I do that, we'll immediately go to our panelists. Each of our panelists is going to talk for about 15 minutes, and then we really want to open up the floor to discussion and Q&A. Now, I'm really excited and delighted to share the stage with three noteworthy experts we have here. I'm not really going to have time to give them the introductions that they deserve, but I provided this slide so you can go to these links and read more about the work they do. But still, I want to just maybe say a sentence about them. First, we have Rebecca. Rebecca is a postdoc fellow at Johns Hopkins Bloomberg School of Public Health, and she holds faculty positions at Indiana School of Law and Lewis and Clark. Her presentation is going to talk about some of the recent developments in laboratory animal law, including the FDA Modernization Act. And she will also, I think, discuss some state issues. Justin is going to speak next. He is the Vice President of Advocacy and Public Policy at White Coast Waste Project, where he's led successful campaigns against taxpayer-funded experiments on dogs, cats, and other animals. He's going to talk about several new federal legislative issues, including increased oversight. Katherine is going to do our cleanup batting for us, and she was the inaugural director of the Animal Law and Policy Center and Clinic at Harvard. And prior to that, she was a partner at the public interest firm of Meyer and Glickstein, which Washington Magazine hailed as one of the most effective public interest law firms in Washington, D.C. That's saying quite a bit. She's going to talk about primate handling standards. And my name is Paul Locke, as I mentioned. I'm a professor at the Bloomberg School of Public Health, professor at the Lewis and Clark School of Law. So let me go quickly through my presentation now, and we'll get these other folks to the stage. So I want to start by just giving you three references that you can consult if you want to know more about laboratory animal law. The first reference is a special issue of the Animal Law Review that covers laboratory animal law. Rebecca and I worked with the ALC editorial board to put that together, and that was published very recently. In addition, I wrote a paper, and I have a lecture that's on the Brooks Animal Law Fundamental site, which you're welcome to visit. And my talk today is going to incorporate a lot of information from those three sources. Okay, so four key concepts that I want to go through. And I'll start with number one, and that is that federal law really occupies this field. Now, in my opinion, right now, federal law is the only meaningful law in the world of laboratory animal law. And there are two federal laws you need to know: the Animal Welfare Act, which I'm sure most of you are aware of. The other one is less well known, the Health Research Extension Act. These frame the field, and you're going to learn more about these during later presentations. But before I leave the slide, I do really want to reinforce this last bullet point. Right now, while there is state legislation, I think there's no meaningful state legislation, and this could be a great opportunity for animal laws and animal lawyers. The second point I want to make is that implementation is really dependent on a system of self-regulation. Now, the system of self-regulation is set up by the two federal laws I just mentioned. And basically, in short, what they require is that every facility set up these internal committees to police laboratory animal law activities in several ways. These committees are called IACUCs, Institutional Animal Care and Use Committees. And they do the bulk of the work, in my opinion, in implementing the laws. There are two federal agencies called APHIS and OLAW that provide some oversight, but I would describe that as kind of light touch oversight. They inspect facilities and they write regulations, but really the substantial day-to-day implementation of animal welfare laws is done by these self-regulatory bodies. By the way, for those of you that love acronyms, APHIS is part of USDA and OLAW is part of NIH. This is another point I want to make, that facilities and species are covered inconsistently. Now, this really relates to the way animals are defined and the facilities that are actually covered by these two federal laws. And the AWA itself has a broad reach because it's based on the Interstate Commerce Clause. So it would cover facilities that engage in interstate commerce, which is most facilities, but it has a definition of animals that is actually quite narrow, and I would even argue counterintuitive. For example, it does not include rats, mice, and birds bred for research purposes, which are the vast majority of animals used in research. It doesn't include aquatic species, and it doesn't include farm animals. On the other hand, the Health Research Extension Act has a much broader definition of animals, but it has a much narrower reach because it only applies to facilities that get money from public health agencies. So what this means is you've got all these facilities out there working with animals. Some are covered by two laws, some are covered by one law, and some are covered by neither law. It is a very unusual system. Finally, the point I want to make is that, again, in my opinion, there's almost no transparency in this system. It's extremely difficult for those who are outside of the system to get information to find out what's going on. You can't really get under the hood. Activities within the self-regulation environment are, for the most part, kept confidential. And to me, one of the most disappointing aspects of the problem is that we really don't know how many animals in total are used in laboratory research and education and testing. There's simply no requirement to count them and to report out these numbers. So that ends my windshield tour of laboratory animal law. I'll certainly try to answer questions when we go to Q&A. But in the meantime, I just want to point out that if you're interested in the work we're doing at Hopkins, please use that QR code. You can learn more about our toxicology policy lab. And please also contact me. I'd love to get your contact information so that we can hook up together on LinkedIn. And also you can follow me on X. Occasionally I post on issues in this field, and I'd love to get interactions with you on that platform as well. So thank you. I'm going to ask Rebecca to come up to the stage now. Thanks.
Good afternoon. Let's see if I know how to use this. I do. Okay. Good afternoon. I am excited to be here to talk with you about some developments in laboratory animal law. My name is Rebecca Critser, and as Dr. Locke mentioned, I'm a postdoc at Johns Hopkins University. I do also want to make a plug for our very new Instagram account that we have. We would love to have you follow us on there as well. And I'm also, fortunate, I would say, to wear a couple different hats in the animal law arena. So in addition to my position at Hopkins, I do have an adjunct position at Indiana University McKinney School of Law in Indianapolis, as well as very fortunate to work with the CALS folks here in Portland. I am the chair of the Science and Tech Subcommittee of the ABA Animal Law Committee. And perhaps most importantly, in addition to my one human child, I am the human caretaker of my dog Ender and my cat Cash, shown here on this slide. So when I was asked to speak with you all about some developments in this space, I was, of course, at first, I'm honored to be asked to speak at the Animal Law Conference, which I too have been a huge fan of since my time in law school. And I want to thank the folks responsible for the Animal Law Conference for inviting me to speak. But then I was perhaps a little overwhelmed because speaking with you all about developments in this space in a 15-minute span is no easy task. So I've done my best to condense it as much as possible, and we'll get through as much of this as we can. And to the extent that we don't cover it all, I welcome your questions later. So a bit of a roadmap, we're going to walk through the FDA Modernization Act, which you may be familiar with. There are a couple different iterations of those, one that's currently pending in Congress. So we're going to talk about that development, as well as walk through the regulatory approval process for NAMs. Spoilers, there really isn't one. And then we're gonna, if time allows, talk about a few state trends around animal testing. And I will say a lot of this is gonna focus on what are known as non-animal models or NAMs. And so I'm going to focus a little bit more on the development of those NAMs and the implementation and adoption, and a little bit less on the welfare side of things. So particularly for those of you who maybe don't have a legal background, just a quick reminder as we move into the topic of FDA Modernization Act. There are a couple of different ways that we interact with the law. And so at this top sort of most authoritative are statutes implemented by our legislator, our Congress, and then our federal agencies, which are part of our executive branch, implement those statutes through regulations. And then we have guidance documents, which actually aren't legally binding necessarily. But I will say from when I worked in industry, they were perceived as defaults. And to the extent that you wanted to go against them, you had to have written justification of why you were doing so. And so just keep that in mind as we work through this first section here. So the Food and Drug Administration operates under one particular federal statute known as the Federal Food, Drug, and Cosmetic Act, or FDCA. It governs the development and marketing of drugs. And by drugs, we mean traditional pharmaceutical drugs, as well as biologics, such as cell therapies, and medical devices, such as stents. These products require pre-market authorization. So before they can really make any money off of them, they have to demonstrate to the FDA that their product is safe and effective. So prior to 2002, when the FDA Modernization Act 2.0 passed, this language that you see up here was part of the FDCA. And you can see it requires applicants to submit to the agencies reports of, quote, preclinical tests. And preclinical just means before clinical, when clinical is in human beings. So before you could try your product in a human, you had to submit preclinical tests. And you can see that parentheses where it says including animals. And we could debate, and I might lose the debate, on whether or not this language actually mandates the use of animals. But at the end of the day, it's not necessarily an important debate because in reality, the agency interpreted it that way and certainly was acting as if animal testing was required. So what happened in 2002? Modernization Act 2.0 passed, which was great. This is going to be our little cat buddy here. It's going to follow along and give you some context for how I feel about the content of each slide. So you can see here, we like this a lot. It's not perfect, but it definitely takes out the requirement for animal testing, and it explicitly includes by name things like cell-based assays, microphysiological systems, computer modeling. Of course, you see element 5 down there is still animal testing. Animal testing is still allowed, but it's very clearly no longer required because as you can see by the bolded text, it says may include the following. So this was a really important step forward. It's been 2 years or so. So what has changed as a result of this? So we have here a regulation, and this was a regulation around the implementation of a drug. So if you want to bring a drug to market, you got to submit an investigational new drug application. And when you do that, you have to have evidence that it's safe and effective. And those evidence have to be based in animal testing. So we changed the statute, but the regulation is still problematic. There's another example of this, but the point is the same. And so what does that mean? It really means the agency responsible for implementing the change in the statute hasn't necessarily done their job. No offense, FDA. And so this is FDA Modernization Act 3.0. This is the next step introduced by Senators Booker and Schmidt. It's a bipartisan effort. There are 5 or 6 additional senators who have sort of co-authored and co-sponsored this bill. And it directs the FDA to publish a final rule on the language I referenced earlier about, shall include the following cell-based assays, microphysiological systems, et cetera. So this is currently pending in Congress and would be a really great step forward. I will also note there is a corollary in the House. It contains more or less this identical information, as well as some additional information that we'll get back to in a minute. Okay, so that's where we are at with the FDA Modernization Act. It was a really good step forward, but we certainly aren't done there. The next thing I want to talk about is regulatory approval of NAMs. And as I already mentioned, there's really no clear pathway. And as the cat emoji is telling us, we're very sad about that. There's really no clear pathway, and that's a problem because companies that are developing these NAMs are increasingly frustrated at the fact that they can't get their product used by industry because regulatory agencies are putting a halt to it or making it very difficult. It's also, I will say, speaking anecdotally from my science friends, very frustrating to those who are in science, who are happy to use non-animal models that are going to be accepted by regulations. Okay, so a little bit of context. There's no clear pathway, but there is a coordinating committee known as ICFAM, which you see up here, and it was started in the early 2000s. And ICFAM is comprised of the head of all of these agencies you see listed here. It started out with the first 15 you see, and then there were 2 additional added. And I just highlighted or bolded for you some that I think people in this room might be familiar with and work with regularly, but they're not any more important in the ICFAM world than any of the rest of them. So there's this coordinating committee known as ICFAM, and this is what they have been tasked to do. And there's sort of 5 items here. I'm just going to highlight 2 for you. So ensure that new and revised test methods are validated. Great. And then, of course, reduce, refine, or replace the use of animals in testing. Many of you may know this as the 3 Rs. This is their job. And so it's really hard to know how successful they've been at this job, but I think many of us in this space are skeptical of their success. So one way of maybe evaluating their success is this database that's actually housed in the EU. I call it TSAR. You can see it stands for Tracking System for Alternative Methods Towards Regulatory Acceptance. And it's actually a database that is a collaborative effort between the US, the EU, Japan, I think Korea, and I'm missing one country, and I'm very sorry to that country, but there's another one out there. So it's a collaboration, and there's a total of 141 NAMs that are in this database. And of that 141, 9 come from the United States. If we think about if the US was doing a proportionate contribution to the development of NAMs, they would have contributed about 23. So we're a little bit shy. On top of that, 8 of the 9 have gone through approval and they have been sort of approved. But many of them still rely on animal use in some way. So they may not be testing on a live animal, but they may be testing on the cornea of an animal that was alive at one point. And so this database is great. It provides information. It's, again, a step in the right direction, but it suggests to us that ICFAM may not be as successful as we would like to be, and they've been around for about 20 years. Okay, so that's a little bit of the downside of things. What's the upside of things? So we have here for you 3 developments that I wanted to bring to your attention. One is the House bill that I mentioned earlier. So in addition to the language around implementing FDA 2.0, the FDA 3.0 language, it also talks about implementing a qualification process and a transparent qualification process. So it says that a NAM is going to be an alternative to an animal model that either promotes greater safety or greater efficacy, or it allows drugs to be developed more quickly. It says that approved NAMs can be used in those drug applications that I mentioned earlier, which is really important. It also requires the agencies to respond to the applications in 180 days. Another really important requirement, we all know how important information is, and reporting is a really big way to get that. And there is a reporting requirement in here. And so part of that reporting requirement is to report out on the number of applications received, the number granted, as well as the number that were actually used in those drug applications. So given that the Senate version of this did not contain this language, I'm not necessarily terribly optimistic that it will get passed this year. But nevertheless, I think it's a good step forward that it got introduced, and maybe in the years to come, it can see some more light. Okay, so I'm gonna skip over, I think, these next two, just because I do want to talk a little bit about state trends. But I will say this ICFAM report came out earlier this year, and it does a nice job of taking a first step towards providing some definitions, which are really needed in this space around validation and qualification in order to, again, increase that transparency. And that last one is an FDA, the subcommittee of the Science Board, the subcommittee responsible for NAMs, put out 6 recommendations for the FDA to consider. Some around a NAM's office, a qualification process, just like the one I mentioned in the House bill. And if you're interested in that, it's a quick read and definitely worth a look. Okay, so let's talk about some state trends because there are some really interesting ones here. The 3 I focused on are rehoming, funding NAMs, and the mandating the use of NAMs. So for the rehoming piece, there are about a dozen states that have implemented laws that require labs to rehome the animals used. And of course, there are a lot of caveats put on that, right? So the first caveat being a lot of deference to the research facility to determine whether or not an animal is appropriate for adoption. There's also species limitations, primarily just to cats and dogs. I will say it provides some civil liability immunity, which I think is probably a good thing because I think labs would be very hesitant to do the adoptions otherwise. And again, this is sort of like good and bad, right? This is a step in the right direction, but it's not the end all be all. There's work to be done. There is a federal effort on this front called the CARE Act. It's been introduced several times. It has yet to pass, but it's something to also keep an eye out. And then I will also add that generally rehoming of lab animals is viewed by most is a very positive thing. Most people who work in labs want animals to be rehomed if they can be. The NIH has even come out in support of this, at least in the rhetoric. But the National Association of Biomedical Research, which is a really big animal testing forward association, has put out, it's like a 3-page how to defeat a rehoming bill. And so if you're working on a rehoming bill in your state, you should take a look at it because it's kind of what you might be up against. I think when you first read it, you might chuckle a little, but then you realize what it's really being used for and how sad it really is. And it's definitely worth being aware of if this is a bill in your state that's up for a vote. Okay, so let's talk about funding of NAMs. Some of you may know that Maryland was the first state last year to pass a bill that created, I believe it's called the Human Relevant Research Fund. And it's a bill that requires research facilities to financially contribute to this fund. And this fund is going to be used by the Maryland government to support the development of NAMs. And it's nice on a lot of fronts, one of which is it's being marketed as being very science and bio forward from the NAMs development perspective. So let's see here. The first payment was in January of this year. I tried to look to see if I could find sort of any information about if it actually happened, if there was any fighting back. I didn't. Maybe my panelists know more, or maybe you guys know more out there. But what I will say is that the fines are based on the reporting requirements under the AWA, and specifically that column F. So if you look at column F, which is the number of animals used, you add them all up, then your fines range from $5,000 to $75,000, and they're not fines, they're fees, I apologize. The fees range from $5,000 to $75,000, whether you have under 100, 100 to 500, 500 to 5,000, or over 5,000. And if you were with me yesterday, we had a small group together, and I was responsible for some math, and you will know that I'm not necessarily the best at math, but I did try to do the quick math here and sort of looked at the research facilities in Maryland, and I looked at how many animals they all have, and if we sort of just follow the letter of the law, what that financial contribution would be. And it came out to around $700,000 to $800,000 for a one-year contribution, which on the one hand seems like a lot of money. And then on the other hand, I really doubt a single NAM could be developed for less than $1 million. So again, a step in the right direction. It'd be interesting to follow Maryland and see how their NAM industry develops, and to see if any other states adopt this law as well. Okay, I don't have time for the last question or the last topic, but I will say some states are mandating the use of NAMs, and the exclusion to that is primarily for all those products I talked about earlier, pharma, biologics, and so it's mostly chemicals and pesticides that it applies to. But if you have questions about that, I'd love to hear them later in the Q&A.
That's not me. That's you. Will someone fix that? I think we need some tech help. Oh yeah, thanks. Someone's on it. Mine has lots of emojis on the opening slide. Well, in the meantime, I'm Justin Goodman. I'm the Senior Vice President of Advocacy and Public Policy at the White Coat Waste Project. There we go. We are a, thank you. We're a 3 million member government watchdog group, and we are fanatically single issue focused on government funding for animal testing. I'm not a lawyer, I'm a lobbyist, which might be worse depending on who you ask. But I'm happy to field questions after this about some of the legal stuff I do. The reason White Coat Waste Project exists is because the US government is the single largest funder of animal testing in the entire world, also in the United States. We spend about $20 billion a year on animal testing, taxpayer dollars, we saw the list in Rebecca's slide. About 20 different federal agencies are involved in funding or conducting animal experimentation in some way. I got my start actually in 2004. That's when I first met Paul, when I was a grad student at the University of Connecticut, and there was a monkey lab on campus that we campaigned against and shut down. But it was funded by the federal government, and that's when I kind of first got the idea that maybe targeting the funders of these projects and not the end user of the money was the way to make a dent. All right, like I said, 2/3 of all animal testing funded by the federal government in the United States. The current estimate is there's about 100 million animals in US labs. 99% of those animals are mice, rats, birds, and cold-blooded animals who essentially aren't counted, which is why we don't really have great data. Public opinion against animal testing has been rising dramatically over the past several decades. A clear majority of the public, Republicans, Democrats, Independents, oppose animal testing. But despite having overwhelming support for ending it, despite all of the evidence that it's incredibly inefficient and ineffective and expensive, it continues. So we have more animals in labs than ever before. And unfortunately, we've done a great job of winning over hearts and minds, but historically have not done a great job in turning that into policy change at the federal level, but we're working to change that, and everyone here is working on that as well. So as an organization, our model is kind of find, expose, defund, our fun acronym FED, since we work on federal policy. And that includes things beyond legislation. Today, I'm going to be talking almost about all legislation, but we work with the law office of Matthew Strugar on FOIA requests to get information from agencies like the USDA and like the VA that don't want to hand over records about what's happening, and the lack of transparency has already been noted by a couple people. And we also work on other efforts. We're working with Advancing Law for Animals and my friend Vanessa Shakib on a cool lawsuit that I'll talk about regarding the oversight of foreign laboratories. What I've learned in the last 20 years of doing this is asking nicely and expecting nice things to happen for animals doesn't work. You have to do things by force. And existing laws aren't very effective. So instead of trying to rely on these really crappy laws that actually don't help animals and help the industry continue abusing animals, we just write new ones. And we try to unite people on the left and the right on Capitol Hill, whether they're animal lovers or people who favor small government, to come together and agree on this one issue. And that's kind of the secret sauce behind what we do. Following the science doesn't work, so we follow the money. We go to these agencies and we try to cut off money for colleges and universities, for private labs that are abusing animals with our tax dollars. And something we do that's very different is we don't try to ban things. Historically, the solution to a lot of animal abuse is if we try to pass laws to ban things. But we don't ban a single thing in our model at White Coat Waste, and you'll see we're pretty effective at passing laws. We just try to defund them and then challenge these people to go find their money somewhere else. And I guarantee you no one is going to pay for the type of things they're doing unless it's taxpayers being forced to. So back in 2016, we launched our first big campaign exposing dog testing inside federal laboratories. The Department of Veterans Affairs at the time was doing the most painful experiments on dogs. We call them maximum pain experiments. These are painful experiments where pain relief is completely withheld intentionally. They were injecting latex into beagle puppies' hearts to induce heart attacks, forcing them to run on treadmills to challenge and induce heart attacks. They were drilling into cat skulls, all kinds of nasty stuff. Obviously, I'm not going to show you photos of that. But that kind of launched our first campaign. And what we did was we started working with Congress to introduce restrictions on the use of dogs and cats in experiments. So at the VA, we got a law passed that required the secretary of the VA to personally sign off on any new project. And it had to meet certain criteria. It had to be absolutely necessary for veterans' health. And it had to meet a couple other benchmarks to then get to the desk of the secretary of the VA to sign off on it. No secretary of an agency wants to be the person who's personally signing off on abusing dogs and cats. And this dramatically reduced the use of cats and dogs in the VA. It still did continue. And over years, we've been able to use an iterative process with Congress to every year tighten up that legislation, add new restrictions in it, until last year we finally got them to put a hard and fast deadline on testing on dogs, cats, and primates at the VA. Where Congress set a deadline for the VA. It said by 2026, you have to completely stop using dogs, cats, and primates in experiments. And not only did they pass that law, it actually worked, and the timeline was accelerated. So they ended the use of dogs officially in 2022. We just got them to completely stop using cats. And we've also learned through the Freedom of Information Act that there's been many projects that have been proposed, but because of all the hoops that you have to jump through and because of the secretary level approval, have not been approved. And there's several projects where they proposed experiments on primates that simply didn't meet the threshold and never happened. Thank you. When we started the campaign, I think they were using 250 dogs in experiments a year, a few dozen cats, a few dozen primates, and now that number is 0. And everything we do is kind of, we try to build on that momentum. So right now we're working on a new bill called the PAW Act with Democrats and Republicans in Congress to extend those same type of restrictions on dog testing at the NIH. We've seen it works at the VA. We've seen that putting those restrictions in place works at reducing and eliminating this type of animal abuse in laboratories. So now we're starting to do the same thing at the NIH. And one thing I want to mention is, and I think it was mentioned this morning maybe on the panel, most laws that get introduced don't ever make it to the president's desk. This Congress is actually historically bad at getting laws passed. There's 18,000 bills, I think, sitting in Congress right now. Only maybe 2% of those are going to get signed into law. It's been better in the past, but Congress is especially dysfunctional now. So we also can't rely on these standalone bills. We have this nice bill with a fun acronym called the PAW Act. That will probably not ever make it to the president's desk, but there are must-pass legislation every year, like the federal funding bills to fund different agencies, like the defense authorization bill, that have to get to the president's desk. And we could take the good ideas from these standalone bills and ideally, if you're politically adept, get them rolled into these must-pass bills that have to become law, and that's how we got the stuff done at the VA. We had a great bill called the Puppers Act and the Kitten Act and the Whatever Act. None of those ever became law, but they help rally people and get them excited, and then we sneak it into a big bill at the end of the year. Also, the threat of these bills is sometimes enough to end something. So we have a bill called the PAW Act that would cut NIH funding for dog testing, but the NIH is already, these labs already see the writing on the wall. So this is a story from a couple months ago. The NIH had planned this new round of experiments on kittens that they canceled because they're afraid that Congress is going to come in and cut the money. So instead of even starting it, they just decided not to do it at all. These are cats who actually came out of the laboratory at UC Davis that was going to be using them in toxoplasmosis. They were going to be scrambling mice's brains and force feeding it to these kittens. And instead, they shut down the experiment and they shut down the breeding colony for the cats. And 30 cats actually got out of the laboratory. 15 of them went to our friends at the Kindness Ranch in Hartville, Wyoming, a sanctuary. And these are some of the cats, and the little orange one there, Marigold, actually ended up going home with our president and founder, who's my boss and friend. So we are literally saving animals' lives. We are not preventing, we're preventing cruelty from happening in the first place, but we're also helping some of their survivors. Again, in terms of keeping momentum up, we're now doing the same thing at the Department of Defense. Every year, they have to pass a bill to fund the military. Again, your feelings about that aside, there are good things we can do for animals in a bill that seemingly has nothing to do with animals. So the DoD, unfortunately, funds a lot of animal testing while also admitting it's incredibly ineffective and wasteful. But we were able to get language in the defense bill for this year, defunding experiments on dogs and cats. It passed in the House, and now we're rallying all of our members of Congress, different coalition groups to come together and urge Congress to keep that provision, defunding dog and cat testing in the final bill that makes it to the president's desk. Paul and Rebecca and I recently did a briefing on Capitol Hill about EPA animal testing. People might remember that under the Trump administration, the EPA rolled out a historic first ever plan to completely phase out animal testing by 2035 with a 2025 30% drawdown date. Unfortunately, literally within months of the Biden administration taking over, the EPA killed this plan to end animal testing. It was mostly at the behest of environmental groups. Sorry, I know some of you are in here. We can agree to disagree on this, though. Thank you very much for the warning. So the EPA scrapped this plan. They completely got rid of the timeline for ending animal testing. And actually, environmental groups are telling them they want them to promise to not phase out animal testing and do more of it. Pledge to them to do more of it, which hasn't actually happened yet. But they did kill the deadlines and say there's no timeline now for them ending animal testing. So what we did is we worked with Paul and Rebecca and others and went to Congress and say, listen, this is something everyone thought was a great idea. Obviously, the administration's been lobbied and did the wrong thing, but we can fix this. So we put language in the EPA spending bill this year directing them to set a new timeline for reducing animal testing and actually producing a report with more data about what they're doing with animals, what it costs, and what they're doing to end it. But we can use creative legislative solutions, again, that are not standalone bills that create more accountability, more transparency, and do save animals. There's just a headline about that. There's also a practice called live tissue training. The Department of Justice and the DoD have been doing it for years, where they stab, shoot, blow up, and burn live animals to teach medical skills. There's been campaigning against the DoD for years, and they have reduced that to some degree. But again, through the DoD spending bill, we were able to introduce language that cut funding for this. And that's the literal language. I mean, there's a little more text, obviously, that was cut off. But this is a law that's like 4 lines long and is literally saving animals from being blown up and shot by the Department of Justice. Again, because it's looking at these things opportunistically, whether it's culture-wise or legislative-wise, seeing where things are moving and where momentum is and kind of tapping into that. We've been working, I mentioned, with Advancing Law for Animals on cracking down on federal funding for foreign labs. The U.S. sends money to 350 different animal labs in foreign countries, including in China and Russia and other adversarial nations. And there is an illegal loophole that the NIH wrote for itself that completely exempts any foreign lab from oversight that's required in U.S. laboratories. So we're suing the NIH right now and having some success. We have some momentum. We've had some mediation discussions with them about closing this loophole so that there is some oversight and accountability in foreign laboratories. Again, the bar is pretty low. In the United States, you can blow up, shoot, burn, decapitate animals. You can literally do anything. The law allows you to do it as long as you fill the right paperwork out. So at the very least, we should have those rules applying to foreign labs, and while we are also trying to strengthen the laws here in the United States. And another success story we had that I'll just give you quickly is we started including language in the FDA spending bill telling them they have to reduce primate use, not defunding it, but just directing them to reduce it. And as a result of this bipartisan language being included in the FDA bills year after year, this is what the graph looks like for FDA primate use since we started introducing that language. It's at historic lows because FDA now knows that Congress is paying close attention and they're going to be embarrassed and their money is just going to be cut off eventually. So they're trying to get ahead of the curve and do the right thing. And again, our campaign started right where that yellow line is, and we saw the numbers drop off dramatically. And we've gotten primates out of FDA labs into sanctuaries. That's a monkey named Moby, who was in a nicotine testing lab at the FDA, who now lives at a sanctuary in Florida. And Rebecca mentioned we're also one of the groups working on lab animal retirement. We have a bill called Violet's Law to retire animals from laboratories, and we actually have some of that language in the farm bill that's coming up. So again, taking a good idea that's never going to pass as a standalone bill and putting it into something that has to pass is a good strategy. These are just some cats we've gotten out of labs. Again, everything we do is bipartisan. That's kind of our secret sauce. This is Republican Brian Mast from Florida and Oregon Senator Jeff Merkley, a great champion for animals, meeting some of the cats we got out of one of the laboratory at the USDA. They now live with folks at White Coat Waste Project. And this is just an email I want to show because this is the VA, an internal email we got through FOIA, thanks to the law office of Matthew Strugar. White Coat Waste has succeeded where other anti-vivisection groups have failed so many times before because they create bipartisan traction in Congress, combining cute kittens and puppies with a message about ending wasteful government spending. And that combination works on both sides of the aisle. So it is what we do is working. It's different. It's unique. But bringing people together who have seemingly disparate interests, folks who you don't think of animal people at all, and showing them how this works for them, appealing to self-interest, tapping into culture war stuff, it works. Not every group wants to do that or is comfortable doing that, but it has shown great dividends for animals. So here's my contact information. I can give my email out. I'm not giving my phone number like earlier today. Sorry, Rachel. But my email is justin@whitecoatwaste.org if anyone wants to contact me, and I'm happy to answer any questions when I'm done. Thank you.
Oh. Somebody made this little cover for my PowerPoint because my PowerPoint presentation is really rinky-dink. So I'm just, no photographs. I'm actually going to be talking about primates, but I love dogs and cats. So anyway, speaking of primates, hello, my primate fellowship here. We're all primates. I think Manny mentioned that. He stole my line earlier today. I was going to start with that. We're all primates. I was asked to talk about a couple of cases that we did that are still ongoing that we initiated when I was the director of the Harvard Animal Law Clinic, and which I retired from on February 1st, by the way. There's a new director, so just so you know that. So I wanted to talk about these cases. I unfortunately am going to rank heavily on the USDA. I know some of you have been very charitable about not saying nasty things about certain government agencies. I'm sorry. I've been doing this too long, so have to let it all hang out a little bit. So in order to talk about the cases, I kind of have to set it up with some background information. So I want to talk about, Paul mentioned the Animal Welfare Act, and I want to talk about that. So it is one of the few statutes, if not the main federal statute other than the Endangered Species Act, that protects animals. The original act was enacted in 1966, and only animals used in medical research were covered by the AWA. In 1970, it was amended to include exhibitions and the pet trade. And then in 1985, there were some pretty great amendments that were passed that we're going to talk about. That was a long time ago. And that's kind of what this whole case study that I'm going to discuss is about. But you see what the overall purpose of the Animal Welfare Act is. It's right there, to ensure, and well, let me finish, to ensure that animals intended for use in research facilities or for exhibition purposes or for use as pets are provided humane care and treatment. It's a very lofty objective of the statute. It's right there in the statute. The word ensure is spelled wrong. And I had a student who was working on one of these cases with me, and every time she had to write that passage in her briefs, she would put sick by ensure. It should be ensure. But anyway, That's the overall purpose of the statute. It sets out a basic licensing scheme for dealers and exhibitors, and then there's a registration scheme for research facilities. And under the statute, the agency is required to promulgate standards for the humane care of animals. You see, it's a mandatory duty, shall promulgate standards to govern the humane handling, care, treatment, and transportation of animals. And then in 1985, and this is to set up what I'm going to talk about, Congress actually amended the statute and added a specific requirement for, by the way, exercise of dogs, a standard for exercise of dogs, but also a standard for a physical environment adequate to promote the psychological well-being of primates. That was in 1985. And we'll get to that in a minute. The statute also has a provision that says the secretary shall inspect each research facility at least once a year. That's it, once a year, at least once a year. And in the case of deficiencies or deviations from the standards promulgated under this chapter, shall conduct such follow-up inspections as may be necessary until all deficiencies or deviations from such standards are corrected. So there's a statutory mandate that requires the USDA at least once a year to inspect research facilities to make sure that they're complying with the standards. All right. In addition, there is a, whoop, let me go back. How do you go back? I had that in. All right, well, I don't have a slide for this, but in addition, there's also a provision that was added fairly recently that also requires the USDA to make public the results of those inspections. All right. So, of course, you've heard this before. The Animal Welfare Act, unlike most of the environmental laws like the Endangered Species Act, the Clean Water Act, the Clean Air Act, the Animal Welfare Act has no private right of action. And what that means is the only entity that can enforce that statute is the United States Department of Agriculture. No one else can bring a lawsuit to enforce that statute. However, unfortunately, the USDA is notorious for not enforcing the statute. And you don't have to take my word for it. Pretty much every couple of years, their own Office of Inspector General releases a report and says, the USDA is not enforcing the Animal Welfare Act. But one thing I want to tell you all, because you've heard a lot about lack of enforcement, and I know there's a lot of law students out there, and maybe you already know this, but I just want to make sure you know this. The reason we can't bring lawsuits against agencies who are not enforcing statutes that they're supposed to be enforcing is because in 1985, the Supreme Court issued the Heckler versus Cheney decision, which holds that no one can bring a lawsuit to enforce, to compel an agency to enforce a statute entrusted to that agency. So that is bedrock administrative law. So that's why we can't bring those kinds of statutes. However, under the Administrative Procedure Act, one can petition an agency to promulgate, amend, modify, or rescind a regulation. And that kind of gets us to where we are. So in 1985, Congress said primates need a special standard that will promote their psychological well-being. USDA did nothing. A lawsuit was brought for their unreasonable delay, which is an APA suit. They finally issued a standard in 1991, and it was a terrible standard. It basically left up to the industry, do whatever you want to, as long as it's consistent with appropriate professional journals or reference guides, whatever that means. Basically self-regulation. We brought a lawsuit. Joyce Tischler and I worked on a pretty important lawsuit back then and established in an en banc DC Circuit case that there was standing to bring those kinds of lawsuits to challenge an agency's failure to carry out its statutory obligations with respect to captive animals. And we had standing to lose because when the case got remanded back to the panel on the merits, we lost. So that horrible standard has been in place ever since 1991. Then in December of 2013, the National Institutes of Health issued new requirements for the treatment of chimpanzees that were still in the possession of labs that had done testing on chimpanzees that was no longer allowed. And the NIH, again, this is for federally funded research. The NIH said chimpanzees need a lot of enrichment. They need others of their species to hang out with. They need things to do in their barren cages. They need things to manipulate, lots of enhancement. So that was NIH doing that in 2013. So a few months after that, I had some clients, the New England Anti-Vivisection Society, now called Rise for Animals, and ALDF, which decided to submit a petition to the USDA that said, well, since NIH has come out and said you need to do this for chimpanzees, we want you to do the same thing with respect to all primates used in research, regardless of whether or not it's federally funded research or not. I'm not sure why there's a wolf over there, but anyway, it's all about primates. We thought this was an easy ask. Your sister agency's doing it for chimpanzees. You should be doing it for all primates who also need enrichment. To make a very long story short, there's a lot that went into this. Of course, immediately, this was amazing. Immediately, the USDA said, this is a really important issue. This never happens, by the way, when you submit a rulemaking petition. This is a really important issue. We need to hear from the public about this. So they put the whole thing out for public comment, which was like, we were very happy about, in the Federal Register. And they got, thousands of comments that said, don't do it. You need to have, yes, grant the petition. You need to change that horrible regulation. Then we heard nothing. So we brought an unreasonable delay case, and when we got an answer, and guess what? The answer was no, we're not going to do it. Meanwhile, back at the ranch, the USDA in January of 2018, I think this is my next slide. Yeah. Put out a request, manatees, another great species, but has nothing to do with what I'm talking about. Talk about manatees though, if you would like me to. But anyway, the USDA told the public in a Federal Register notice, hey, we're thinking about using third-party certification as a means of deciding how frequently we should inspect research facilities, all right? And we want to know what the public thinks about that. And there was, public comment, and they said, whatever you do, do not do that. And in particular, do not let the American Association for Accreditation of Laboratory Animal Care, the acronym is ALAC, whatever you do, don't defer to ALAC, because ALAC accreditation is meaningless. It's an industry group. It's they've all got all kinds of conflicts of interest. They don't even use the Animal Welfare Act standards when they do their site visits every 3 years. Whatever you do, do not defer to any ALAC certification. In fact, Justin Goodman and a colleague of his, Alka Chanda, did a wonderful peer-reviewed study of ALAC accredited facilities. And guess what? Their rate of compliance with the Animal Welfare Act was worse than non-ALAC accredited facilities. So lots of public comment, don't do it, don't do it. And so the agency actually announced that based on all those comments, these are what people said, and Justin's wonderful peer-reviewed study demonstrated. And then the USDA said, yes, we're not going to do it. Public has convinced us not to do it. Great. Okay. That gets us, so meanwhile, our petition is pending. We get a response to our petition, and the petition is denied. And there's a dog over there. Thank you for trying. I should have done it I should have put some primates in there. But anyway, one of the reasons given for why the petition was denied, as you can see, this is the agency speaking, is they say, we don't need it. This 1991 regulation is doing just fine with the primates. They're being treated just fine. And by the way, we don't have to do it because every time our inspectors go in there, they examine and document all areas of care and treatment that are covered under the Animal Welfare Act, including the enrichment plan they have to come up with. The inspector also observes the regulated animals, inspects the facilities, including enclosure, housing, material, space, and records. And if the inspector observes that the facility is not in full compliance with the AWA requirements, he or she will explain all deficiencies and appropriately document the findings. That's what they said is the basis for their petition denial. Now, those of you who have taken administrative law, before we get to that, when we got this response, we kind of talked to some of our friends, many of whom are here in the community, and we said, really? What do you think about this? And they were like, well, wait a second. I'm pretty sure they stopped inspecting ALAC accredited facilities, which is, if true, is huge because most research facilities in this country are ALAC accredited, like all the big universities, the big medical facilities, they're all ALAC accredited. So this is not a minor point. We said, what do you mean they're not doing it anymore? Well, we don't know for sure, but that's the rumor that we heard. So we had our students do a Freedom of Information Act. This is why I wanted to hear Jamie sing her song, maybe later. She claims she's the FOIA queen, but I don't know. I might have to challenge her on that. And we did a FOIA request to find out what the scoop on that was. And this becomes significant because, as those of you who have taken administrative law know, one of the bases for challenging an agency decision under the famous State Farm case, which sets out the standards for arbitrary and capricious standard of review, is if an agency has offered an explanation for its decision that runs counter to the evidence before the agency and other reasons. So if in fact the agency had stopped inspecting ALAC accredited facilities, this would be huge. So it turned out that in fact, we found out from the FOIA request, this is the document that we found buried in, they gave us thousands of, we had to sue them first under FOIA, and then we got the documents. And in this document, you will see, it says, as of February 2019, we issued guidance that made it mandatory rather than discretionary by inspectors to perform focused inspections at ALAC accredited research facilities, unless the research facility requested a full inspection, which never happens. And that this license, what is it called? I can't even see the focus. This focused inspection counts as that annual inspection that I told you is required, mandated by the Animal Welfare Act. This was revealed in a FOIA document. Also in the documents, don't tell the public about this. We don't want the public to know, et cetera, et cetera. So we then amended we had a lawsuit pending. We filed a lawsuit challenging the denial of our rulemaking petition as arbitrary and capricious because it runs counter to what we have discovered, which is they're not inspecting all the animals and the facilities. What they do under this focused inspection is they mandate that the inspectors can only look at one aspect of the facility. When they go in for their annual once-a-year inspection, they can either look at the paperwork, they could look at the facility, some aspect of the facilities like expired medicine on the shelf, or they can look at the animals, and even then, they only have to look at a sample. So you're talking like 3 years goes by before they even have to look at a single primate that's being kept at a research lab. So we then filed a lawsuit challenging the policy as violating that mandate that I started with. That requires annual inspections to make sure that facilities are in compliance with all of the with all of the standards. And both of those cases now are pending in the Fourth Circuit Court of Appeals. There's so much to say about both of them, but actually both have been stayed right now and they're in mediation. And so you'll have to wait and see what happens. To be continued. And I'd be happy to answer any questions about the lawsuits or anything else that might tweak your interest about this whole area. Thank you very much.
Please join me in thanking the panelists. Well, we clearly learned a lot. First of all, there are a lot of creatures I never knew were primates that are primates. But I think what you saw here is really what administrative animal law looks like and what you can really do to make the administrative system try to turn and, if you will, do the right thing. So we now have time for questions and comments, and I'd ask you to come to the microphone if you have a question or a comment. Just a couple of ground rules. If you've got something to say, great. If you want to ask a question, great. If you want to make a comment, great. but just please limit your time to about a minute or 2 minutes. And especially if there are people behind you, you can circle back around, or if there's no one behind you, we can keep going. So please go ahead and start.
Thank you so much. Can I ask, how do you determine how much of your energy and resources you put into ending animals used for research versus their welfare while they're being used for it?
Sure. Did everyone hear the question? Yeah.
Repeat it.
Okay. Would you like to, anybody like to try to address that? I'll start, but okay. So if I understand, you're asking about ending versus trying to improve welfare.
Yeah.
So I would say from my perspective, both are goals that are really, really important. And I think to some extent, from our perspective, we are working towards, my group at Hopkins is working towards getting animals out of research, but in our view, this is going to be a long-term effort. The way we do it is we try to improve the science and create a fertile ground for the science to develop, as Rebecca said, by adding more discussion about what a validated test looks like, by getting NIH to actually support more research on alternatives. But there are a lot of people who are working on the welfare side, and that is incredibly important too. There's a connection between the two, because if you get people thinking about enhanced welfare standards, then they're also going to start to think about, oh, maybe I shouldn't be using animals in the first place. I wanted to turn to panelists, see if you wanted to add anything.
That's a good answer. I mean, I spend 0% of my time working on welfare improvements because there are other people doing that and who are more equipped and interested in that type of thing. I'm interested in getting animals out of cages. That's what I'm here to do.
I feel compelled to add for my students that are currently in the animal legal philosophy course that I take a bit of a new welfarist approach, where I tend to think sort of implementing welfare along the way can lead to the long-term removal of the animals. But certainly what we do is a lot of also advocating for the substitution, the replacement, the NAMs that I talked about earlier.
Thank you.
I'll just add with one comment, and then we'll go to the next speaker. In 1959, which for those of you that aren't good at math was about 65 years ago, there are two scientists that came out with these concepts called the 3 Rs, which still govern the way we use animals in research. Those concepts are based on good science and humaneness. And one of the key features of that group of scientists is that you cannot do good research without having humane treatment. So this is not like a new idea or a radical idea. This is a fundamental idea.
Hi, my question is for any or all of the panelists. My name is Amy Semmerkamp. I'm a 1L at UC Davis, which I'm aware was mentioned in the presentation regarding, like, we do a lot of animal testing on my campus, and I'm sure other students' campus as well. So my question is kind of on behalf of all law students in general. I've heard a lot about FOIA this weekend. What would you all say is the best path or recommended path for law students to take who want to take action at their schools against animal testing? Is FOIA the first and best step, or are there other recommended routes that you think we should do?
Yeah, I'm happy to go. I think so FOIA, yes, FOIA is so important. There's limitations in California in the state records laws about research records that you can get. It's actually very limiting and favors the university and the animal experimenters, but you can get a lot of information about what's happening at UC Davis from the NIH through federal FOIA. So that's probably a more efficient and effective way to get information. There's also, if you look through the USDA's website, you can get data on how many animals are there and what type and the pain categories of research, or looking at published papers from UC Davis and seeing what they're actually doing without getting documents through FOIA. Transparency, sunlight is the best disinfectant. I really feel that way with all of my work. A lot of these people are going to be scared out of doing this stuff, but just because they're afraid of being criticized publicly and exposed. So if they feel there's a groundswell of support in the student body of people who are kind of gunning for them and trying to stop what they're doing, you're going to get people who just throw their hands up and say it's not worth the trouble. So just exposing things and working with the student paper and working with local press and trying to get attention for those things is very, very important. The cat lab we stopped at Davis recently, through a variety of different ways we found it, they stopped it. The reporter, the animal experimenter responded to a reporter saying he decided not to do it because White Coat Waste Project was targeting him. Our targeting was submitting a FOIA request. Literally, that's all it was. We had done nothing publicly at all. So that's, in terms of the fear factor of being exposed, that's one of the most effective weapons you have.
I would just add to that, I do think education and outreach are probably would be most effective on campus. My hesitation with FOIA, having been a student who submitted FOIA requests, is they take a long time. They take longer than what they're supposed to. And I think I got my FOIA response that I submitted as a student a year or two after I graduated. And so if you really want the material, right, you may not get it as quickly as you would like. The other thing I would add is if your school has a legal clinic of any kind, or you can join, I think clinics are a great way to get hands-on experience. Even if they're not animal law directly, if there's some indirect route you can take, and they're really good guidance for taking proactive work.
The way to get documents under FOIA is when they miss the deadline for responding to you is to file a lawsuit against them. And then once you file your lawsuit, you get Matthew, there's a bunch of people in this room that do FOIA cases. Once you file your lawsuit, they start to give you documents because they don't want to have to litigate with you. So it can be very effective. And also, I totally agree, media attention is definitely the way to educate the public and put pressure on the facility.
Op-eds, letters to the editor of your local paper, or the school paper, anywhere, yeah.
Yeah, we also have a blog site. You're welcome to write a blog for us, just a little shameless advertising for my program.
Much for the presentation. My name is Eva. I'm from Zimbabwe. I learned a lot, and I saw that there are a lot of similarities, especially with the struggle of the Animal Welfare Act. We have got our Prevention of Cruelty to Animals Act. But my question is, how are your relations with the government? Because I know there's a lot of conflict, there's a lot of interest. I mean, how do you manage the relations beyond the work that you do? Because there are a lot of violations that I see that happen in my country, and everybody's tagging me like, this is your issue, this is your issue, you know? Like, for example, right now we're dealing with the culling of elephants. I mean, different context, but same issue. How do you manage the relationships beyond the work that you do?
I can answer that, but do you want to take it?
I mean, as far as I'm concerned, the government is the enemy. And too many animal groups have been captured by government agencies and don't want to criticize them publicly because they have a good relationship with them and they think that something's actually going to come of that, and very rarely does it. All it does is prevent groups that could be criticizing and using their resources to criticize the government from not doing it, because they like doing webinars and having photo ops with these agencies, and actually nothing ever gets done to help animals. We're very adverse, my organization, not every organization, I mean, we're very adversarial. We see that they have never done the right thing on their own, so why should we expect them to? And we're going to use Congress and grassroots energy and the press to pressure them into doing the right thing against their will, usually.
What he said, he said. No,
I'm not.
I think theoretically.
Go ahead.
So I just think theoretically, it's a nice idea. Like, we could work with the government and get things done. And we've tried that for decades and we aren't getting anywhere. So I'm in the same camp as Justin on that.
I'm not going to disagree, but I'm going to tell you that I do work with the government when I can. Not all the time, but if I can, because my feeling is, you know, as a scientist, sometimes just being in the room and saying, you know, that doesn't make any sense. You know, like, you're using this model, and then I look at the literature and the model has been non-informative for 30 years. Why aren't we moving on? That has, you know, it's behind closed doors. That has helped. However, that being said, there are some times when a good poke in the eye really gets you pretty far. So I think it really is it depends on the circumstance. I think what you heard from both Justin and Katherine are instances where being forceful has really made a difference. My, you know, my situation, you're not going to hear about those things because they're behind closed doors. But it you know, really, I think is going to make a difference. The difference is going to be, what do you want to get out of it? And what opportunities do you have? And also, whether you think the government is going to listen. I think what you heard here is that often the government is not listening the way we'd like them to. Let me, before I go to you, sir, let me go to someone over here. You had a card up, 5. We have 5 minutes? Okay.
Hi, my name is Brooke Paul. I'm from Villanova Law. I think my fellow law student who had just asked a question a second ago kind of captured a similar sentiment to what I'm asking about. I'm not a lawyer yet. I'm not a lobbyist yet. But I am a constituent. So I guess my question is, do your respective organizations have any resources for constituents to express their interest in animal welfare? And if so, how do you access them?
I mean, everything we do, any petition we send out, groups send out petitions, fine, they're all different types of petitions. Everything we send out, or the lion's share of what we send out, is actually something where you fill out, your information might be pre-filled in there because you're on our mailing list, but it's going to directly send an email to your representative and your 2 senators. And we have millions of people doing that. And I then follow up at all of those congressional offices and say, X number of your constituents wrote you about this specific issue. What are you going to do about it? So we try as an organization to make it as easy as possible for you to reach your members of Congress, not only so you can do that because it's your right, but also because it makes our work more efficient and effective if you have that direct line to them. Phone calls are the best way for a constituent to make their voice heard, because ours too. I mean, all the emails, everything's so automated now that they kind of expect to get buried under emails. But if you call your local, your congressperson's local office, they never get phone calls. The phone never rings. There's usually no one even there to answer it. But if they get a call, they're going to call the DC office and say, hey, people have been calling us about whatever X issue is, and it's going to get on the radar of people. So the squeaky wheel really does get the grease, but you just have to know where to make that noise. And I think on the local level, the hyper local level, showing up at your congressperson's local office and saying you want to talk to someone about something, that's the most effective way to get it done.
Thanks to the panel. Dr. Locke, when you gave your comments, you mentioned that state law is an area of maybe white space where there's some work to be done. I was hoping you guys could talk about some of the areas where a budding lobbyist might put their efforts. I know we talked about rehoming and the Maryland law about NAMs, but are there any other areas that are kind of glaring for the panelists? Thanks.
Yeah, thank you for that question. I'm just going to quickly answer it because there's a lot to say about it. In the Animal Welfare Act, there is language that says this is not only a federal thing, states can get involved too. Now, basically this opens the door for states to really be in the space of regulating laboratory animal laws. To the extent that the states can do it, I think we're trying to work on figuring that out, but the invitation is there. And ironically, it's been there since 1985 when they put these amendments in place, and no state has really taken them up on it. So maybe we can talk later about some of the efforts. I think states could be very aggressive in this area and make a big difference.
Good afternoon. I'm Brian Hackett. I've worked in government affairs, and I currently do that for our state's largest animal protection organization. During my time working for national groups, I've worked on legislation such as the rehoming and the banning the sale of products, certain products tested on animals. So those things on the periphery of this. I have mixed feelings about how effective those things really are at the end of the day. But a thought that's gone through my mind listening to your presentations, which have been fantastic, and thank you all for your amazing work, is have any of you given some thought as to the supply of the animals to the labs, in sense of the Invigo case with the beagles in Virginia, which was massive. I know a ferret advocate who told me that a large percentage of ferrets are, bred by one particular breeder. What are your thoughts and ideas about getting at the supply side for the animals that are provided to the labs, whether on a state or national level, as trying to chip away at that? I mean, Justin, you've been amazing with going directly head first at the government, but putting pressure on those breeders and the suppliers of the animals. What are your thoughts on that strategically?
It's funny you mention this because one of the campaigns we're launching this fall or later this fall, probably December, is related to this specifically, and looking at the supply chain. There's three main places that are supplying animals to labs. It's these commercial breeders like Invigo, and Invigo is this massive breeder that had tens of thousands of puppies, beagles that they sell to laboratories. But there's other companies just like that. So even though Invigo isn't selling puppies anymore, thanks to the good work of some people here, there's other companies like Ridgeland and Marshall Farms that have picked up the slack and also are basically puppy mills that specifically supply animals to be tortured and killed in labs. So they come from commercial breeders. There's a lot of breeding colonies at colleges and universities that are breeding animals to be deformed or sick in some way, specifically for experiments, and they're breeding thousands of animals as well. And then there are also loopholes that still allow people's discarded pets to either be taken from shelters or directly given by companion animal owners to laboratories and used in experiments. So we're looking at what type of solutions we might be able to come up with. Some of those. Some of them we can do some defunding and restrictions on funding and spending to companies that are not compliant and things like that. But yeah, I'd love to talk to you more about what you're thinking about it too, because I think it's a big part of the problem.
Yeah, I think the other beagle breeder is in New York. And, if there's a political circumstances to prohibit the breeding of animals in a state for anything other than companion purposes, laws like that, being creative and novel to get at the supply is worth some thought.
Yeah, definitely. Thank you.
We have one more question, and I know Rebecca had a quick comment. So did you want to add in?
I mean, I'll just say that we also started thinking about the breeding side of things. And, in addition to the Invigo, we have the DOJ case with the macaques coming out of outside of the US. And, one of the problems there is sort of we've stopped the flow from outside, but now they're talking about increasing breeding inside the US. And so I just raised that to say it's a very complicated area, but I think you're wise to look at that. I think it is a space that we all should be looking at more. And I know I think for our team, we're sort of starting with that, educating ourselves and then thinking about what the next step is. So thank you for that question.
Yeah, we did have a major victory in that there was a massive primate facility that was slated to be built in Georgia. I don't know if you heard about this, and there was so much pushback that got canceled. So.
Hi, my name is Grace. I'm a law student at the University of San Francisco. And I just wanted to ask how you respond to or contend with the position that's been advanced by some of the environmental nonprofits in the letter that you showed regarding the EPA and taking a position that there are environmental justice concerns or that overburdened communities have a particular interest in continuing this. So I'm not entirely familiar with the whole scope of that letter, but I was just going to ask how you've made sense of that or any particular things that come up in contending with those arguments.
Okay. I know, I see we have the big goose egg in terms of time, so maybe we'll try to answer this question. Did you have a quick question afterwards? Or? Okay, so maybe we can take these two questions and then we'll let everyone out for the break. Anything you wanted to?
I think it's a great question. We've looked into this because we actually published a piece. What did we publish it in? The forum?
The Environmental Forum, yeah.
Thank you. And they included a companion piece, I think unexpectedly to us, that made this exact point that I think it was probably the same author. Yeah. And so we were like, what is this person talking about? Why are they so? I was very curious. And we looked into it a little bit. And I will say it's somewhat nuanced, very sort of narrow reason why NAMs are being so opposed by the Environmental Agency. And it has to do with this policy around what the threshold is for an environmental chemical. And this NAMs came in and sort of changed the threshold in a way that the environmental groups think is creating more danger. But their assumption is the NAMs doesn't work, right? Their assumption is the NAMs is faulty, and so that's why they're concerned in some respect. And I'd be happy to talk with you more about the specifics of where this all comes from. But it's really interesting and in a lot of ways feels counterintuitive that a group like an environmental group would be so against something like this. But that's my understanding of where it comes from.
Thank you.
That's all right.
John Lieberman. I'm a first year MSL student at Lewis and Clark and also a retired physician. And for the first 15 years of my career, I had no concept, didn't even think about animals and research, despite the fact that as medical students, we read about it and learn about it. And probably 100% of friends and colleagues who in general love animals also don't think about it. And as the providers who write for medications, including medications that look good in animals and then have unintended consequences leading to harm in patients, we deal with it regularly. And so I mention it, as it was mentioned up there, how important outreach is. And during this first semester, I've learned the term public outrage in terms of a concept that sometimes advances the needle forward more quickly than otherwise would have. And so my question is to my knowledge, physicians are not too much involved in this movement. And granted, we have our own issues with human healthcare that we're dealing with. However, I think there's a large majority of physicians who, if they knew more about this, might be a potential voice for helping the movement. In addition to the patients who take medications, which it took $10 billion to get to this drug, which might not even work in the real world. So comments or thoughts on trying to involve more both the healthcare community and the patients who are the end consumers of these medications.
Yeah, I think physicians, yeah. Go ahead.
Physicians Committee for Responsive Medicine, so.
And there's some
That's-
bad folks here, I
Yeah,
think, at this event.
those are the physicians that are, I mean, there is an organization of physicians that are focused on that issue, so
I think that's,
obviously the more the merrier.
yeah, I think that's right. We should make sure we call out PCRM for their work. We should also point out, though, that the AMA could maybe be more actively involved. On the other point you made, I think it's a really important point for us to really consider, because there are all these disease-specific groups where they are frustrated by the pace of science. And one of the things we've thought about is how we can work with them to point out that if they use these new approach methodologies, things could happen faster, particularly in areas of rare disease where you just, you're not really going to ever have enough people to do clinical trials the appropriate way. So those are good opportunities. And maybe when you finish law school, you can lead the way on that. All right, I'm afraid we're going to have to stop now. I really want to thank everybody for being so actively involved, and really appreciate your comments. And again, thank the panel for their work.
Thanks, everyone.